Hello, everyone. Welcome to Court with Krissy. Here are 4 court shorts you probably didn't catch, and I'm kicking it off with my favorite. Watching this parking enforcement officer lose? It's a major win. I hope you like it. Court with Krissy is now in session.
The court calls case number 25, P like parking, 160667. This is people of the city of Royal Oak versus Brian Michael Fiander. That's you, sir?
Fiander, yes, sir.
Fiander. Mr. Fiander, you were present a bit ago when the court explained the nature of an informal hearing. Is that true?
Yes.
So you also understood the court to instruct that you must select from one of 3 options in the protection of your own rights. Is that also true?
Yes, sir.
Thank you. Did I say Fiander? It's Mr. Fiander, right?
Fiander, sir.
Fiander, I'm sorry.
I've been getting it that way my whole life, sir.
I had a 50-50 shot at it. Sir, the citation before the court is a rather simple one, and it indicates that on June the 16th of this year at 4:07, a vehicle plated to you or a member of your household was improperly parked in the South Lafayette parking structure in as much as it was in a designated zone for small car parking, and therefore the citation is for improper parking. You may, at your option, admit responsibility in this matter. You may admit and explain, or you can deny responsibility, and we will swear the parties and take testimony. What do you wish the court to do for you?
Sir, I wish to deny responsibility and contest that my vehicle is in fact a small vehicle.
Very well. Please raise your right hands. You will solemnly swear the testimony you shall give before this court shall be the truth, so help you God.
I do.
I do.
Thank you very much. Officer Bonacorsi has the burden. Then it's your turn. Officer.
On June 16th, 2025, I was doing parking enforcement in the South Lafayette parking structure, checking all of the spaces that are marked small car only, and came across this Honda, I believe a CRV, with the license plate. And being that a Honda CRV is 106.3 wheelbase, I issued a citation because it's just over the cutoff for what we're considering small vehicles.
And what was the wheelbase of the CRV?
106.3.
Okay. And the rule of thumb that you have deployed as a parking enforcement officer is
106 and higher.
a 106 and higher.
So anything anything below 106 does not get a citation.
Very well. Mr. Fiander, what would you like the court to know?
So I did a couple of searches to try and understand how this citation could have happened. If you were to do a Google search of Honda CRV wheelbase, the very first hit you will get will be the 2025 model, which has a wheelbase as was noted of 106.3. However, the vehicle that I drive that is licensed to me and has that license plate is a 2015 Honda CRV. If you look at the Honda specifications, and I have those available, it indicates that that vehicle has a wheelbase of 103.1 inches.
Okay. And so your testimony is that give me the year model again.
My vehicle is a 2015 model.
Okay. Please stand by.
Sure.
Very well. Anything further you wish the court to know?
Knowing that the cutoff is 106, I had searched to see if I could find where such a requirement was listed. I couldn't find one posted, so I had done some additional evaluation of the size of the parking spot and but if the cutoff is 106 and my vehicle actually has a wheelbase of 103.1, I don't feel it's necessary to go into the other information I've gathered.
Okay. You may be an engineer, but you're thinking like a lawyer. So well done. Is there anything else you want the court to know, sir?
No, I think just trying to keep it to simple and to the point of facts, sir.
Very well. Rebuttal testimony.
No, Your Honor, other than I don't know model years when I look at a vehicle, so I just have to.
Understood.
Understood. The
Right.
court believes all the parties are testifying truthfully and acting in good faith. The court does note that in particular that 2015's wheelbase is 103 inches. For that reason, at this time, the court will find you not responsible, sir. Now, if you go out and buy a newer model, you'll know where your cutoff is.
Yes, sir.
Historically, anything in excess of 105 actually is found to be in violation. But that being said, you take care. Good luck to you.
Thank you, sir. Thank you, officer. Have a good day.
You're welcome.
And Your Honor, this is one of the cases where I did not, thank you, Lieutenant Carey. I'm still trying to get you that parade, sir.
Thank you.
Oh, and Judge Hayward, in case you don't know, Lieutenant Carey stopped a school shooting a few years ago.
I wish he had been there today. They had another one in Minnesota. Thank you for what you did then, Mr. Carey. I mean, Lieutenant Carey.
Thank you.
Because they have one today. At the current count, I believe 2 children have been killed, and there are others who've been injured.
17 was injured.
Yeah, 17 people injured. All right, so this is Ms. Taylor.
Yes, Your Honor. And I was unable to get in contact with Solicitor General Brooks. However, I am willing to offer Ms. Taylor a suspended fine if she would like to plead today. It would be a suspended fine of $100.
I'm not guilty.
All right. So this is Angela Yvette Taylor, 2024 TK 06429, improper parking. Who's the witness in this case?
Your Honor, it's going to be Officer Kirilova. I believe that we won't need any other. I think we still got Officer Discorbeth. He's free to go. I don't know why he's still on here, but you're free to go, sir. You have it going, okay?
Okay, you got Detective somebody, Alexander. I think we took a plea in their case, or the case was no problem.
Oh, yes, I see Detective Alexander's also on here.
All right.
You're free to go.
All right, so Kirilova, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. Mr. Tipton, your witness.
Yes, thank you, Your Honor. Officer Kirilova, we've been through this a lot today. Do me a favor. Say your name for the court, please.
Officer Kirilova, Clayton County Police Department.
Okay. Are you currently post-certified?
I am.
Being post-certified, are you authorized to investigate crimes, issue citations, and make arrests based on your citations?
Yes, sir.
And how long have you been with Clayton County PD?
7 years.
Okay. Have you been post-certified during the entirety of that 7 years?
Yes, sir.
Okay. And I want to draw your attention to March 21st, 2024. Were you working for Clayton County PD at the time?
Yes, sir.
Okay. And in working for Clayton County, were you on duty that day?
I was on duty, yes.
Okay. And what were your duties that day?
I was responding calls for services and doing traffic enforcement.
The occasion to go to Mount Zion Road near Terra Boulevard or at the intersection of Terra Boulevard?
That is correct.
Okay. Why did you go there?
I was dispatched to a motor vehicle accident.
Okay. I'm sorry. Can you give me a moment, Your Honor?
I'm
Yes.
sorry.
Go ahead.
Okay.
Yes.
Your Honor, I just heard from Mr. Brooke. The state's moving to null process case.
All right, Ms. Taylor, your case has been no pros. You're free to go at this time. Thank you.
Okay.
Thank you for your patience.
Thank you.
All right, ladies and gentlemen, that concludes the court's calendars.
And he emitted an odor of alcoholic beverage, so we were concerned that he may be impaired. We had Mr. Huey come up from probation with PBT, and he tested at a .212. So based on that, we would ask that he be held in contempt and taken into custody.
Mr. Staggers, you want to say anything today?
I just want to have the case continued. My lawyer's on vacation, and I'm just asking.
Okay, who's your attorney?
Christian Rowland.
Okay. He hasn't made an appearance in this case yet.
No.
Were you aware of that? Okay.
No.
All right. All right, you want to say anything as to your bond?
No, sir.
Okay. I mean, you can't show up to court drunk, obviously. Ms. Yeager, you wanted me to revoke bond on the basis of contempt, or what did you want me to do?
Yes, please.
Based on the alcohol test, I'll find Mr. Staggers in contempt of court. I'm going to revoke your bond today, set your bond at $2,500 cash surety, no alcohol, no drugs. You understand that, Mr. Staggers?
Yeah.
Okay.
Yes, sir.
Anything further, Ms. Yeager?
No, Your Honor.
All right. Have Mr. Rowland get in touch with the court if he's going to represent you, Mr. Staggers, okay?
Thank you.
Good afternoon. Are you Charles Sears-Patowski?
That's correct.
So we're on the record in case number 25-5314FY. You're appearing for arraignment purposes this afternoon. You're appearing with your attorney, Mr. O'Keefe. Mr. O'Keefe, did you have opportunity to review the allegations on the complaint, nature of the offense, and the possible maximum penalties with your client?
No, I've not, Your Honor.
Would you like a breakout room?
I have yet to see the complaint myself, Your Honor. And I apologize. I've been very under the weather the last couple of days, so I think that would be appropriate.
I guess I'm not clear on, would you like a breakout room with your client so you could have a conversation with him before we continue with the arraignment, or would you like me to read the complaint on the record?
Let's read the complaint on the record, Your Honor.
So the complaint, again, case number 25-5314FY, alleges count 1, being lawfully required to depose the truth as a witness in a trial, a court proceeding in a case of People versus Abigail Sears-Patowski, 24-14844-FH, the case being OWI, serious injury, before the 13th Circuit Court, Grand Traverse County, did commit perjury by testifying as follows. Abigail Sears-Patowski, his wife, consumed alcohol after she drove and collided with another vehicle, and he saw her consume some of that alcohol personally while they were on their way to the hospital. Contrary to MCL 750.422, it's a felony and it carries with it a 15-year penalty. Count 2 alleges obstruction of justice. Did commit the crime of obstruction of justice by speaking directly with the prosecutor and providing false information to the prosecutor in order to have charges dropped. Contrary to MCL 750.505, It's a felony and it carries with it a possible maximum penalty of 5 years imprisonment and or $10,000 fines plus court costs. Probable cause alleges on August 31st, 2023, Abigail Sertelski was involved in a collision with another vehicle in Grand Traverse County. Her husband, defendant Charles Sertelski, arrived on scene before law enforcement investigators. Defendant then volunteered to transport his wife and daughter to Munson Hospital. While at the hospital, defendant told Grand Traverse Sheriff's Deputy Hunter that his wife had consumed approximately 3 glasses of wine at a party between 1800 hours and the time of the collision, approximately 20:33 hours. A blood draw was conducted at the hospital. As a result, Abigail Sertelski was charged with operating while intoxicated, causing serious injury to the occupants of the vehicle she struck. In February 2024, defendant met with Assistant Prosecutor Kyle Atwood, who was assigned to prosecute Abigail's case. During that meeting, defendant presented new evidence, in quotes, that his wife had consumed alcohol only after, and that is in italics, the collision while she was in his vehicle. Defendant is a Michigan State Police trooper and is trained and experienced in criminal law. He is aware that claiming post-driving alcohol consumption is a recognized defense to an OUIL charge. On March 5th, 2025, defendant testified under oath on behalf of his wife in the 13th Circuit Court, People v. Abigail Sertelski, file number 24-14844FH. He told the court and jury that following the crash, Abigail drank 2 small Fireball liquor shooter bottles, and that he stopped her partway through drinking a 3rd shooter of clear tequila. He further testified that she did not drink any alcohol prior to driving. Defendant changed his testimony after being confronted with the opinion of the defense expert, who had concluded that the alcohol attributed to Abigail's blood draw results could not be explained by consumption of only 2.5 shooter bottles. In response, defendant testified that Abigail had also consumed a glass of wine at a dinner meeting before attending the party. That is the entirety of the complaint. Mr. Sertelski, you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, the preliminary examination will be scheduled for September 16th. It would be at 11 a.m. with Judge Stepka. Also, on or before September 9th, you will have a probable cause conference. With us this afternoon is also the special prosecutor, in this case, Mr. Chamberlain from Leelanau County. And Mr. O'Keefe, I'll start with you. Is there information that you would like me to know regarding bond? You are muted, sir.
Yes, Your Honor. Trooper Sertelski has no previous criminal history. He has stable ties to the community. He's not a danger to the community nor a flight risk. He has children at home. Obviously, his wife is currently in prison. Sister, I believe, is there to take him home. Given that he's a public servant, he's of modest means, and I believe he's currently suspended without pay by the MSP. So I would ask that the court obtain a personal recognizance bond.
For the people, Mr. Chamberlain.
Thank you, Your Honor. I do concede all the facts that Mr. O'Keefe just stated. I would also note that Mr. Sertelski knew that this was coming down probably for about 3 months and stayed in the area. He was cooperative with law enforcement upon arrest. I, however, think that there should be some monetary bond, whether it's 10,000, 10%, or something else. I leave to your discretion, Your Honor.
I don't see the need for any monetary bond. The praxis score obviously is very low. And thank you, as you have indicated, Mr. Chamberlain, as well as thank you, Mr. O'Keefe, for your information, that knowing for some months prior that a charge was coming, here he is today and has turned himself in. I'm going to place you on a $10,000 personal recognizance bond. Conditions on the bond are that you may have no threatening, intimidating, harassing, or violent behavior towards any person. You'll be respectful of all court employees and care providers during the course of your case.
Yes, ma'am.
There is a recommendation on the praxis for no contact with the Grand Traverse County Prosecutor's Office staff unless the prosecuting attorney initiates that contact, but I think that would probably go without saying at this point. Mr. Chamberlain, any questions, sir?
I don't know if he has any active cases with Grand Traverse. I would just request anything along those lines go through his attorney, through me, and then I'll work with the Grand Traverse Prosecutor's Office.
Mr. O'Keefe?
That's fine, Your Honor.
Is that fine with you? Okay. So if you have any active cases for which you must provide information to the Grand Traverse County Prosecutor, please work through your attorney, who will then in turn work with Mr. Chamberlain to get that information to Grand Traverse County.
Understood.
Thank you. I need to verify contact information with you, please. The court will mail notices regarding the date and time of the preliminary examination and probable cause conference. Mr. O'Keefe, probable cause conferences can be handled prior to the time that it's currently scheduled on paper with a discussion between you and Mr. Chamberlain in this case. Mr. Chamberlain, do you have any questions?
No, thank you.
And Mr. O'Keefe?
No, Your Honor, thank you.
Thank you very much. And Mr. Sersky, you are all set.
Thank you.